The previous video, Frontier, covered the period from 1788 until 1830. So at the end of this time period, the British have just gained sovereignty over the territory of New Holland and Van Diemen's Land via the Anglo-Dutch Treaty of 1824. So the British have acquired sovereignty over the territory according to their own law and under their own interpretation of international law. In this video, I'm going to continue on exploring the ramifications of this treaty in terms of its effect on Aboriginal sovereignty and Crown legal jurisdiction over Aboriginal peoples, and also the reception of British law over the land. Now, I'm going to use an analogy in this video because it's kind of an abstract, legalistic and technical subject. The British internal logic goes something like this analogy. Imagine a large house or a big mansion with hundreds of rooms. There's an Aboriginal nation in each room. There is also a separate, smaller building, like a shed. That separate building is Van Diemen's Land. The Dutch claimed the entire property by putting a massive flag outside of the smaller building. Now, New Holland is recognised as Dutch sovereign territory from between when Abel Tasman planted the flag in 1642 and when Cook came along in 1770. Proof of this is that other European powers stayed away from the place for 128 years. 128 years is a long time. Now that's an implicit recognition in the international community of the Dutch claim over the territory. In international law, wide recognition is how sovereignty is determined. Other European powers stayed away from the area because they acknowledge it has been in Dutch possession. So the Dutch had some form of internationally recognised claim over both New Holland and Van Diemen's Land, and also New Zealand. So in 1773, the British, Tobias Furneaux on Cook's second voyage, notices that the shed that Tasman put his flag out is actually separate from the main house. Now the British see this and they move into the part of the main house. But the British are still not sure if the main house is really claimed by the Dutch. The British move in, but they are not confident of their own status and they are unsure if they have a clean title. They tread fairly tentatively and carefully at the start. During the Napoleonic Wars in about 1800, the British move into the shed simply to prevent the French from moving in. At the conclusion of the Napoleonic Wars, the British come to a settlement regarding their respective possessions in the East Indies with the Dutch in the 1824 treaty. Now this treaty is a bit like the British acquiring or buying both the house and the shed off the Dutch. This was a settlement in the sense of the legal definition, as in a settlement as in finalising an ongoing dispute. In this treaty, the closing date, or the date that the house keys are supposed to be handed over, was on the 1st of March 1825. Under the terms of this settlement, there is a grace period for non-British inhabitants to get out of the property, and that grace period is 6 years. The inhabitants, the Aboriginal nations, are not informed of the sale or of the treaty, nor of their 6-year grace period. The British fully clear out the shed, or Van Diemen's Land, after 6 years through the Black Line. The British then declare everyone that's in the house that's not there with British Crown permission as a trespasser. This happened in the Burke Proclamation. Over time, the British gradually move into each room in the house, gradually giving inhabitants notice that it's not their land anymore. The inhabitants are still not told that their home has been sold out from under them. You could say that as a result of the 1824 treaty, Britain got a kind of nominal de facto sovereignty title over the territory. But at the time, the British didn't even have control over most of the acquired territory. They had no police or courts in the outback, for example. And it was still possible at this stage that the acquisition of sovereignty through the Treaty of 1824 would not be recognised by the international community. The international community might roll their eyes and say, "Come on, you British, you can't get sovereignty over New Holland through a treaty with the Dutch. You've got to do a treaty with the natives." Now, the story of the colonisation of Australia is multi-layered. There's a second story about how the British acquired sovereignty. The second story goes something like this. The Dutch never had any claim over the land in the first place. They were never interested in New Holland. No other European power had any interest in New Holland either. Then James Cook claimed the territory outright through the principles of first discovery. First discovery comes under the Doctrines of Discovery, and it comes with the obligation to protect the interests of the native inhabitants. This duty was fulfilled with Protection Acts. Aboriginal people were nomadic with no sense of land ownership, so the land was not stolen and no treaty was needed because Aboriginal people had no concept of material ownership. Aboriginal people only ever had a spiritual connection with the land. The British actually did Aborigines a big favour by introducing civilisation. Aborigines are now better off because they can enjoy 60 months interest-free at Harvey Norman's. So which one of these two stories is the real foundation story? The 1824 treaty story or the first discovery story? The answer is that neither of these stories were ever committed to. The British hedged their bets on both scenarios and tried to make their actions consistent with both accounts. Now, both of these stories fell apart later down the line after changes in international law after World War II. At that point in time, the new foundation stories start emerging, but I will cover those when I get there in this chronological series. As of pre-Federation times, these are the two main stories in play as to how British acquired sovereignty over the territory. So, next in our timeline sequence after the Anglo-Dutch Treaty in 1824. So the British reckon they acquired sovereignty over the territory. So the timing is now right to ask, where do Aboriginal people fit into this arrangement? So this video will cover from the 1824 treaty until 1889 and focus on the legal status of Aboriginal people. Around this same time, in the United States, they are also considering this question. The question of where to place the native people in the newly independent system that retained some colonial roots. In the United States, these major decisions happened using the courts during the Marshall Trilogy. The Marshall Trilogy is a set of 3 landmark court cases which determined the status of native peoples in the newly independent United States of America. These rulings drew a lot on the philosophies behind the Doctrines of Discovery, and very selective parts of these rulings were also drawn on by Australian courts. These 3 cases from the Marshall Trilogy are marked on the timeline here. Also around the same time, New Zealand's situation was sorted out by the Declaration of Independence of New Zealand and the Treaty of Waitangi. So the courts in New South Wales did something similar as in the United States. The colonial system in New South Wales used the courts as a tool to set policy to determine the place of the natives in the system. I'm going to go through some of these court cases that happened around the time of the 1824 treaty and show how Aboriginal people were placed and how their land was stolen. Firstly, here is the timeline. So here are the 3 key dates from the treaty to keep in mind. The 1824 treaty is where the sale happened. In our analogy, in our house analogy, this is like the papers being signed for the house sale. A year later in 1825 is where the house became British. In real estate terms, this would be called settlement or closing date. This is when the ownership is transferred and the keys are handed over to the new owner. And later here, in 1830, any non-British inhabitants have until this time here to get out. So the natives have a right to occupancy until this date. The court cases and other events discussed in this video fit amongst these key dates of the treaty. Not long after the key handover date, on the 1st of March 1825, the private land sales began in New South Wales. Now the start of private land sales is significant because it was a shift that made Crown land grants privately alienable. This really changed the nature of colonial land grants and opened up things for land speculators. Why didn't the Crown do this earlier? Think about it, it is not really possible for the Crown to allow private land sales unless the Crown itself has the right to alienate land titles. So this shows that at this time, the Crown seems to have taken the position that it now has the power to alienate land. Now, I think this is directly because of the settlement of the treaty, which just happened a few months beforehand. In 1827 was the court case R vs Lowe. So this is the first court case I will talk about here with regards to jurisdiction over Aboriginal people. For the purposes of this video, I'm not concerned so much about the verdicts or the outcome of the courts, but of questions of jurisdiction. But for some background, this was a death in custody. An Aboriginal man was in custody of a policeman, and he was handed over to some military fellas. He spent that night before his death in chains, and for some unknown reason, the military fellas marched him off and executed him the next day by firing squad. Also, another important thing to note of background is that this occurred in Newcastle, so it was in a settled area. Now, the court decides that it had jurisdiction over this case because, quote, the court looks at the Act of Parliament only. If the Act of Parliament has recognised a sovereignty over this country and recognised the application of English law here, we must look to the British law as established here, de facto, and the court is of that opinion. The offence charged against him is that of having taken away the life of a native. Now, this native must be considered, whatever his denomination, a British subject. If not to be an alien friend or an alien ami, in any case he is entitled to lex loci, and it is only under peculiar circumstances that he can be excluded from that right. His Honour was decidedly of opinion that the natives of this colony were within the protection of the laws. So in this case, the court reasoned that because it happened in Newcastle and because it happened in a place where the court had jurisdiction, that they could try the case. The courts also decided that they have some kind of duty of protection for the Aboriginal man who was murdered. Now, protection has kind of a double meaning here. Now, what the court says is His Honour was decidedly of opinion that the natives of this colony were within the protection of the laws. Now, the first meaning of protection is a European first discoverer, under the Doctrines of Discovery, has an obligation to protect the rights and interests of the natives in a newly discovered land. Now, this is why European discoverers usually bothered making treaties, even if they were tokenistic and one-sided, because discoverers are supposed to at least pretend to protect native interest. The second meaning of protection could be this. The Crown has an obligation to protect the rights and interests of the subjects of that Crown. Now, this is kind of related to the Magna Carta, how the Crown is supposed to look after its subjects. Now, the court doesn't actually say that he's a British subject, but they say that they should treat him as a British subject for purposes of this case. Now, if we go back to the house analogy, so the settlers have moved into the room in the house. Now, the native man who was murdered at this time in 1827, he still has a right of occupation because, well, the keys have been handed over to the British, but in 1827, the Aboriginal people still have a right of occupation. So the court has decided that this native has an entitlement to protection of British laws because he's in the settler room with settler courts and settler rules. But the court does not actually say that he's a British subject. So there are two different potential meanings of protection here. So which one is actually relevant? Well, the court doesn't actually say that the man who was murdered, the Aboriginal man who was murdered, was a British subject, but he said that he is entitled to the Crown's protection. Now, that's really interesting because at this stage, Aboriginal people still have a right of occupancy in the house. Even though the house keys have been handed over to the British and the British own the land now, it doesn't override the Aboriginal right of occupancy. I guess the courts are asserting a duty of protection because they consider themselves to be first discoverers. So another case that was in the same year, in 1827, R vs Tommy. So this was a case where an Aboriginal man killed a settler. Now, this happened in Georges Plains and it was in a rural area. The court again steps in this time to protect the settler who is clearly a Crown subject. Now, the court does this by trying an Aborigine for a crime against a settler. Now the court decides that they have jurisdiction in this case, and this Aboriginal man named Tommy, he's found guilty and he's hanged. The next year, in 1828, what's called the Australian Courts Act is passed, and this is the full reception of English law. 1 year after that is R versus Ballard or Barrett. So this is a really interesting case. An Aborigine kills another Aborigine, and it's presumably done under Aboriginal law. And it happens in a very populated area. It happens in the Domain. Now, very interestingly, in this particular case, the court rules that it has no jurisdiction. And here is the reasoning from Judge Dowling, who I think was the Chief Justice of the Supreme Court. The savage or the foreigner is equally entitled to protection from British law, if by circumstances that law can be administered between Britons and the savage or foreigner. Amongst civilised nations, this is the universal principle, that the lex loci shall determine the disputes arising between native and the foreigner. But all analogy fails when it is attempted to enforce the laws of a foreign country amongst a race of people who owe no fealty to us, and over whom we have no natural claim of acknowledgement or supremacy. We have a right to subject them to our laws if they injure us, but I know of no right possessed by us of interfering where their disputes or acts are confined to themselves and affect them only. Most undoubtedly, it is murder in an Englishman to kill an Aboriginal native without excuse or reason. So the law of England would hold the native amenable for destroying an Englishman where the injury was unprovoked. The same principle of protection applied to the preservation of property, although the notions of property may be very imperfect in the native. The Englishman has no right to wantonly deprive the savage of any property he possesses or assumes a dominion over. On the other hand, the native would be responsible for the aggressions on the property of the Englishman. Okay, so you see there's an interesting thing that the judge has done here. Seemingly, he takes a tangent out of nowhere and he makes a link between the protection of the person and the protection of property. Now, this link will become more important later. Now, my interpretation of this ruling is Aboriginal law is still the law of the land as it applies for Aboriginal versus Aboriginal disputes, as we still have at this date in 1829, as Aboriginal people still have, proprietary rights in the land, in which Aboriginal law is inherently tied to, right? Now, time-wise, this is interesting where this case happens, because it happens in between the reception of English law and that 6-year grace period end where Aborigines, basically become trespassers on their own land. So the court has ruled no jurisdiction over an Aborigine killing another Aborigine. Now, one thing that this no jurisdiction ruling shows is that the reception of English law in the year before, in 1828, did not extinguish Aboriginal law, even in a highly settled area such as in the Domain. Aboriginal law was still recognised at this time. But just a year later, those proprietary rights that the judge here has tied to Aboriginal law are effectively extinguished, because in 1830 is where that 6-year grace period ends and Aborigines become basically trespassers on their own country. So what happens in 1830 when this 6-year period ends? The 6-year grace period actually starts from the date of ratification in 1824. So that's why it's 1830. So let's look at this from like a house analogy. So the British have bought the house from the Dutch, and now the British consider themselves to have full ownership of the house. But there's still people living in the house from before the British obtained the house from the Dutch. So as of this date in 1830, the Aboriginal people become trespassers. Now the British can be nice and exercise a prerogative, I guess, to let the Aborigines stay at their discretion as long as they don't interfere with British interests. Now this is the dynamic that continues to this day. You know, white material property interests reign supreme. Today, Aboriginal interests in the land are further minimised in the Uluru Statement as being spiritual only. We're going to jump ahead a little bit and go to the Batman Treaty in Port Phillip. So this happened in 1835. So just some background if you've never heard of this case. So this settler fella called Batman, he tried to do a treaty directly with some Aboriginal people in Port Phillip, and that's where Melbourne is today. So he was going to give them some, I don't know, blankets and bags of flour and stuff to buy some land. Now, what's important about this case is you've got to look at it in both terms of time and space. You need to recognise where and when this happened. Now, the location of Port Phillip is important and it's very relevant here. Now, if you look back to this first discovery map from the previous video I showed, so notice here that Port Phillip is not on the east coast. So it is not under a first discovery claim by Cook. It's also not in the Murray-Darling catchment. Now, theoretically, under the Doctrines of Discovery, only the first discoverers, in which case would be the Dutch Crown and its agents, only the Dutch have the right to do a treaty, not Batman, because Batman's a British subject. Now, this is actually reaffirmed in one of the articles in the Anglo-Dutch Treaty, where the British Majesty agrees not to treaty with any chiefs of islands south of the Straits of Singapore. Now, as for the timing of the Batman Treaty, if this treaty had happened before 1830, I think the Crown would have had to allow it, because during that 6-year period between 1824 and 1830, Aboriginal people had the right to sell up their land and leave freely as they wish. But the Batman Treaty has happened well after the 6-year period has expired, 5 years after it's expired. Also, if you look at the organisation involved in this treaty, Batman was very well organised and provisioned. He had translators and everything. He had a big setup. And it would not surprise me if he was put up to it by the Crown or maybe some local colonial agents or maybe land speculators. The end result gave the colony more power. Now, if you look back in the United States, in this case in 1823, which I have on the timeline here, this Johnson versus McIntosh case, that was basically a setup for land speculators. And maybe the Batman Treaty was the equivalent of this. So in 1835, on the 26th of August, was the Governor Burke Proclamation. Now, it's a pretty common belief that this Burke Proclamation was a reaction to overturn the Batman Treaty. But I'm going to look at it in terms of the Anglo-Dutch Treaty of 1824. I think it's actually a formal declaration of those reception of those lands from the 1824 treaty. So what's happened is they've waited for the treaty. The British have waited for the treaty to finalise, and then they've waited a little bit to give, 5 years to give the Dutch a chance to challenge. And the Dutch haven't challenged, so now they're saying, okay, this is all Crown land now. This is all British Crown land. Now, this proclamation is actually explicitly referred to in later on in the next court case I'll talk about, R versus Murrell. And it's referred to as of when possession is taken of the lands, right? So this proclamation is really where the Crown asserts and declares radical title. Shortly after this, New Zealand declares independence. Now, keep in mind that New Zealand was part of New South Wales at some stage. So in 1836, on the 5th of February, 1836, there was another court case, R versus Murrell. Now, what happened in this case? It was, on the face of it, it's pretty similar to R versus Ballard. We have an Aborigine killing another Aborigine in a populated area. This has happened in Windsor. Now, unlike R versus Ballard, where the court decided they have no jurisdiction, in this court case, they decided they did have jurisdiction. Now, there's a lot of head-scratching commentary about this case, because a lot of people are looking at R versus Ballard, where an Aborigine kills an Aborigine, the court decides there's no jurisdiction, right? And then just 6 years later, the same thing happens, an Aborigine kills an Aborigine in Windsor, in a populated area, and now the court has jurisdiction. So what happened? What happened in the meantime? And the difference between the case is time. Now, if you look at this timeline here, it appears that the expiry of that 6-year treaty period and or the Burke Proclamation actually changed the outcome of this. It wasn't the reception of English law, because that happened before R versus Ballard. Yeah, so you could say this: 1830 is when Aboriginal people lost their right over their land. Basically, their house was sold out for them, and they lost their right of occupation on that date. It wasn't actually declared until the Burke Proclamation. So moving along another couple of years is the Myall Creek trial. So the Myall Creek trial was on the 15th of November 1838. Now, remember how I said earlier, at this stage there are two different, narratives, stories about how the British acquired sovereignty. So one of them is via this Anglo-Dutch Treaty, but another one is that the British acquired it by first discovery of the entire land by Cook. Now, this event, the Myall Creek trial, relates to the first discovery by Cook. Now, recalling from my first video about the specifics of Cook's first discovery claim, Cook specifically used the word rivers in his possession claim. This means he claimed river catchments. Catchments, not up to the high water mark, as some planted disinformation that's going around says. You've got to read Cook's actual claim. Now, recalling also something else, the first discoverer Crown has a duty to protect the interests of the natives. This is under the Doctrines of Discovery. Now, out of the many hundreds of massacres that occurred, Myall Creek Massacre, this is the only one, as far as I know, that perpetrators were held to account. But why did they bother with this one trial at all? Now, there's a clue here in the location name. Myall Creek is part of a river system. What the trial does is it reinterprets Cook's claim of first discovery of rivers to extend not just to rivers that flow into the Pacific, but over the entire Murray-Darling Basin. Now, because Myall Creek is a part of the Murray-Darling Basin, it doesn't flow into the Pacific, yet it is pretty far east. So this is a way for the Crown to claim first discovery over a larger area. And they do this by demonstrating that they are protecting the interests of those Aboriginal people who were murdered in the Myall Creek Massacre. Now, the site of the massacre, it lies east of Abel Tasman's easternmost discovery. Now, as Cook sailed along the east coast, he was both directly south and directly north of this massacre site. So this means the land around Myall Creek wasn't claimed under first discovery by any European power. Now, if you look at this map here, see, it's in a no man's land. And what I mean is that this land around Myall Creek was not claimed under first discovery by any European power, unless you resort to an extended interpretation of Cook's claim over the rivers. Now, what this trial is a signal to the international community that the Crown is first discoverer of the land, and also that the Crown is a first discoverer over this particular little place in the Murray-Darling Basin. Now, it also came on the tail of a Royal Commission, the Royal Commission is also a kind of internationally facing signal. So the duty of the first discoverer Crown to protect the interests of the native peoples was demonstrated here. But this was later undone in 1998 during the secret women's business Hindermarsh Island Bridge case. In this Hindermarsh Island Bridge case was where the courts decided that the legislative can use the racist power to make laws detrimental to Aboriginal interests. Now, this is actually very poetic, is because Hindermarsh Island actually lies at the other end of this river system that Myall Creek is in. It's actually literally where the blood of those slaughtered at Myall Creek would have flown into the salty sea. So the Crown asserted a right of first discovery and demonstrated that protection of Aboriginal interests in Myall Creek to just later on undo it in Hindermarsh Island. The Treaty of Waitangi happened a few years after that, and then in 1841 was R versus Bonjon. Now, this is another case where an Aborigine kills another Aborigine, but this time it is in Port Phillip. Now, as I said before, the British don't have a first discovery claim over Port Phillip. So this case may be a little bit different. Now, I think the purpose of this case was to test the jurisdiction that the British had over Aboriginal people that was outside of British first discovery lands. So this case was in what was New South Wales at the time, but it is in like Port Phillip, so Melbourne now. And in this case, an Aboriginal man killed another Aboriginal man. So you would expect it to be like R versus Murrell, right? Yep, the court has jurisdiction. Pretty straightforward, right? No. And the difference is that this area is not under British first discovery. Now what happened is the courts, they sat there and they talked a lot about jurisdiction. And in the end, they didn't make a decision. I think it's because of the location. Because unlike Murrell in regards to a murder that happened in Windsor, which is definitely in a place of a Pacific flowing river catchment, and it's not in the Murray-Darling catchment. So the British do not have first discovery in Port Phillip. Now, as the British do not have first discovery in Port Phillip, there's no protection duty under the Doctrines of Discovery. So the courts just left it hanging. Now, that issue left hanging for quite a long time until Federation was around the corner. So we're going to jump forward a few decades now. In 1889 to a court case called Stuart v. Cooper. The Stuart v. Cooper case was about land titles. It wasn't about Aboriginal issues really, not directly. So what happened is that someone was passed down a title to land that was originally issued by the Crown on the 27th of May 1823. The person who held this old land title was complaining about some out-of-date conditions that was stuck on the title itself. Now note that this original land title was issued by the Crown not long before the 1824 treaty. Now, it might be the case, depending on which of the multiple foundation stories that the British want to go with, that the British Crown was handing out land grants before they actually acquired the land via the 1824 treaty. So you can't hand out land titles that aren't yours to give out, obviously. And this might be the case for any pre-1824 land grants. So I think this court case is to fix up a loose end that might need to be fixed up ahead of Federation. Now, it was this case, Stuart v. Cooper, which led to some Privy Council advice regarding the colony being practically unoccupied and peacefully annexed. If you read this advice with knowledge and appreciation of the context of the Anglo-Dutch Treaty of 1824, you can see how this advice has been later misinterpreted to mean something else. Or in other words, the local Australian doctrine of terra nullius. So here is what the Privy Council advice said. The extent to which English law is introduced to a British colony and the manner of its introduction must necessarily vary according to the circumstances. There is a great deal of difference between the case of a colony acquired by conquest or cession, in which there is an established system of law, and that of a colony which consisted of a tract of territory practically unoccupied without settled inhabitants or settled law at the time when it was peacefully annexed to the British dominions. The colony of New South Wales belongs to the latter class. There was no land law or tenure existing in the colony at the time of this annexation to the Crown. Now this advice comes from the Privy Council. This comes from London, and they would know about the treaty. What they're doing here is they're talking about the reception of British law into a new land. Now, if, let's say the British acquire a new land, and what they want to do is introduce their own British law into that new land. Now, if there's already laws there in that land, you want to do it kind of gently, because if you go and plonk your law up on top of other land that's already operating in that thing, it's going to be kind of chaos. And that's what they're talking about here. Now, if you look carefully at the wording here, they make a distinction between places where there is an established system of law and a place that is without settled inhabitants or settled law. So they're saying here that New Holland is without settled inhabitants or settled law. I think what they're really saying here is that there's no Dutch settlers in New Holland or in New South Wales. There's no leftover Dutch settlers. There's no leftover Dutch laws in effect that the British have to take into consideration when they are applying their new laws into this land. They're not saying that there's no Aboriginal law or there's no Aboriginal people there, right? Now, the reason they're talking about Dutch settlers is because that's who they've done the treaty with. Now, the local colonial system has taken this and goes, oh yeah, there's no law here, and just gone and run with it. It's a colony which consisted of a tract of territory practically unoccupied without settled inhabitants or settled law at the time that it was peacefully annexed. Now, it was peacefully annexed because they're talking about annexation of New Holland. They're talking about annexing it from the Dutch. There was no fighting between the British and Dutch over New Holland, right? There were no settled inhabitants. There were no settlers there. There were no Dutch settlers there. There was no Dutch settled law there. And more importantly, there was no Dutch land tenure law there. That's what they're saying, okay? So the British are saying, oh, well, there's no Dutch land tenure law here, so we're going to put our own land tenure law here, right? So they're not saying that the colony was terra nullius. They're just saying there's no Dutch there. So then locally, the courts in New South Wales have taken this and run with it and said, well, just blame the Privy Council for everything. So the New South Wales colonial system and the Privy Council, right hand and the left hand, one hand pretends like they don't know what the other hand is doing. The New South Wales courts take this advice and say, oh, well, we don't have to worry about Aboriginal land tenure law then. We don't have to worry about Aboriginal law at all. And that's how we fell through the cracks. Now, I just want to touch briefly on the Mabo decision, because in the Mabo decision they decided to, I guess, quote unquote, overthrow terra nullius. And they're also saying that the acquisition of sovereignty over Australia was by settlement. Now, the Anglo-Dutch Treaty of 1824 was a settlement treaty. A settlement is when you have some parties and they're going through this ongoing dispute, and then they come to an agreement at the end of that dispute, and then everything's good again. Now, what's interesting is that word makarata, or makarata, which means coming together after a struggle. That also means settlement. So everyone thinks settlement as meaning when a group of people move to a new land and they start building a little town. That's not how sovereignty was acquired by the British. It was actually through settlement as in a legal agreement with the Dutch. What they're doing next is they're going to replace that 1824 Dutch treaty with Makarata, because Makarata is a settlement with the Aboriginal people, coming together after a struggle. That is literally, in a legal sense, a settlement.